The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, Treasure Coast and beyond. This is Ask a Lawyer on Friday, January 18th, 2019. Last week we had a little absence here, and you got a 2-hour block of Ask a Rabbi. Hopefully you got educated on Talmudic law. This week we're going to talk about a smorgasbord of topics and see how far we get. But first I want to say a couple things. Cliff's introduction at the end of Swap Shop was a wonderful introduction. It was classic. Cliff said, whatever he says. He's right. Whatever I say. Doesn't mean it's right. But that was just a great intro. Thank you, Cliff. Anyway, also, next week is the last week of our first year. Wow. 1 year. I hope they bring me a cake. But it's really been a year. And we're going to start the second year off with a little something different. I have a guest attorney coming in to join me, and his name is Andrew Reich of Reich and Mancini. They have offices in St. Lucie West and in Palm City. And we're going to talk a little bit about workers' compensation and Social Security disability. And Andrew is very knowledgeable on that. One thing I will tell you folks, you get injured on the job, get an attorney. Don't just let the employer's really nice about it. They send you to the doctor. They're taking care of your medical bills. Get an attorney. Protect yourself. And we'll talk a lot more about that when Andrew is here. Social Security disability. It's very easy to file on your own. But to maneuver through the governmental process, even when there isn't a shutdown, is complex. It's best to do it with a lawyer. So we will talk about that as well.
Well, it's
not next week, in 2 weeks.
It's a long process, right? And
Yes, it is. Yeah. So on February 1st, the first show of our second year, Andrew Reich will be joining us from Reich and Mancini, and I think you'll find it very interesting, and if nothing else, you won't have to listen to me all hour. All right. We are going to discuss a bunch of things today. The first thing is, I've been dealing with a case, which is still ongoing, involving a partnership where the two partners no longer like each other and they can't agree on anything. And the operating documents for the partnership say that they both have a 50-50 vote, and to do anything requires a majority. You can't get a majority when you're 50-50 unless it's unanimous. That means you both agree. Mm-hmm. I have seen this before.
So they need a mediator or someone to break that tie.
Well, that's the problem.
Yeah.
That's where, I have seen this before. Small corporations, limited liability corporations, partnerships, where it's, two people, and it's 50-50, and the share, the stock or whatever is 50-50, and so they say, okay, we both have one vote, and the documents are standard, says majority decision. Well, I want to do this, and I don't want to do this. Who wins?
Well, it sounds to me like they have no business anymore, so they should just take their half and leave.
Well, that's easier said than done.
Okay.
Small business may not have much value to somebody else. Somebody else who wants to buy, they want to buy a 50% interest? Maybe not.
Well, okay. I would think that you have to take your marbles and go home And I take my marbles and go home.
Oh, so in other words, you dissolve the business.
Yeah.
Well, if it's a good business, then you're both taking a real bath. There are other answers. The first answer...
Kind of like a divorce.
Yes, it is. It is a business divorce. The first thing is, don't set up your business where it's only two of you and you need a majority decision to act on day-to-day activities of the company or significant activities of the company. Because if the two of you don't agree, it's called a deadlock. And Florida statutes provide that a deadlock is one of the circumstances under which you can file an action in court to dissolve the company, or there are other alternatives. It's expensive. You don't want to get to that point. It is better when establishing your partnership, your business, your corporation, that hopefully you're doing it through an attorney, and hopefully that attorney isn't the one putting in the majority provision, but that there be another mechanism to resolve disputes, whatever it is. But without that mechanism, you have a deadlock. You have enough deadlocks, you can't function. One person wants to spend $5,000 on advertising on WPSL, The Talk of the Treasure Coast.
Yay, we would love that.
And the other one says no. You can't do it. It seems like no always has, overrides a yes.
Well, yeah, if you ever listen to Dr. Laura way back when, she's been gone for a long time, but her philosophy is the no always wins.
Right, because the no is the status quo. And, a yes to do something means doing something different. And if you both can't agree, you can't do it. Enough of those, and, a business is in jeopardy. Sometimes you don't want to dissolve the business. You want to either buy out the other person or have the other person buy you out. Sometimes that's a little bit difficult. It's even difficult to negotiate. And sometimes
but if it's 50-50, I know what I own, and I guess I owe you the same.
Well, no, because now you have to value the business. What is the business value at?
But can't an outside auditor type person come in and tell you that?
If you both agree that you're going to accept that person's
oh my goodness.
decision.
Okay.
Now, a lot of times, what will be suggested is, okay, you pick one, you pick one, and those two will pick another one. And then either you'll take the midpoint or, whatever. You'll have a mechanism for decision. We do that a lot of times in arbitration clauses. It'll be, okay, you pick an arbitrator, I can pick an arbitrator, and those two will decide on another arbitrator. So that hopefully, theoretically, your arbitrator is going to rule with you.
You're trying to find a neutral person.
Right.
And everyone's satisfied that this person is definitely
right.
neutral.
And the truth is, this is when you are suspicious of the other side, because the reality is, in my experience, the reality is, the person you choose is not necessarily going to find for you. And the person he or she chooses is not necessarily going to find for him or her, because they have respect for their own position and their own ethics and reputation. So it's not so simple as I pick my guy.
Right.
But the reason is they pick a third one is precisely that reason, because you have some suspicion that each person's person is going to vote for them. So the thing is, don't set it up that way. It is probably the most significant problem I see when a business comes to me and says, I'm having a problem with my partner or my shareholder, my co-manager, depending upon the term in the statute. Because there are three chapters of Florida statutes that deal with this. You got Chapter 605, which is limited liability corporations, 607, which is Business Corporations Act, and 621, which is Professional Services Corporations. And they all essentially say the same thing, but for different ways that you can organize. And they all interplay with each other. But the best way to do it is when you're setting up your operating documents to have a real mechanism to move forward, even if you two disagree. Because you two are going to disagree. In the best marriage, people are going to disagree. Certainly business partners are going to disagree. You have to have a way to move forward on something so that you don't stand still and you don't stagnate and you don't disintegrate. So.
And that can affect a lot of people. I mean, just let's say you have employees.
Absolutely.
And now you're messing with their lives too.
Well, and if we want to take the government shutdown theory of it's not just the 800,000 who aren't getting paid, it's all the contractors, all the people that they would pay, they would buy goods from. Yes, you're right. It's not just the two of you that are being affected. It's your customers. If you are a professional corporation, a medical practice, a legal practice, it's your patients, your clients, cases. And if, for example, in a medical practice, if we take that as an example, and you're saying, okay, we're going to dissolve the business, that means all those patients have to find new doctors. So it does get to be significant. And the best thing to do is have a mechanism to avoid the problem. And the reality is nobody is perfect. But if you go to a good lawyer to draft your corporate documents, and I will happily say that's not me. So I'm not making a plug for myself here. I'm just saying if you go to a good business corporations lawyer that is involved in, organization of businesses, not litigation, hopefully they will anticipate most of the problems that are likely to occur. So there is a way to deal with them, and you can get through the periodic differences of opinion that people are going to have. Without that, you end up in my office, and you end up in litigation, and you end up paying a lot of money in legal fees. Really, a lot of money. Sometimes it even bothers me to issue the invoice, monthly, because it's sticker shock. So good advice. Ask a lawyer before you form a business, and try to deal, with all the things that might happen, just like if you were married, and you're trying to anticipate.
Well, everything's wonderful in the beginning.
That's right. I know, for example, way, way back in the 1970s, my father also went into a partnership with a buddy that lived, a few houses down. Everything was fine in the beginning, but not so fine later on. The business ended. That's not good for anybody. So it happens. It happens all the time.
And the friendship probably ended as well.
Yeah. And, just like people get divorced, you have business partners that have disputes, and then it gets emotional, and then it gets angry.
Well, you can't get past it, I guess.
And if there's a mechanism to deal with that, then you could avoid getting to the extent of anger where you can't function together. You have this mechanism to resolve the dispute, and you move forward. It's sort of like, well, I don't like that we're ending up doing that, but okay, this is what this mechanism tells us to do. And another time it's going to be the other one. Says, well, I really don't like doing that, but all right, this is how we're going to handle it.
Well, how about if they go, well, we agreed on that then, but I don't agree on this now.
Well, that's always a possibility, and then it's either buy one each other out or go to a lawyer.
Yeah.
The best thing to do really is not even to necessarily have a mechanism, but this is scary, is to, if it's a couple people, one person has 50.1% and the other has 49.9%. So one is a majority, one's a minority.
Who's going to be that person who has control?
The interesting thing is that majority, that extra 0.1% interest, makes your interest in the company much more valuable, because nobody wants to buy. A stranger doesn't want to buy in as a minority, 49.9. Sure. So if you're going to do that, then when you're setting up the business, probably the person who's going to be 49.9 is going to contribute less to get that interest in the company than you are going to contribute to get your 50.1, because you're buying that majority interest so that certain day-to-day decisions essentially can be made by you. Although the governing documents could say for certain significant decisions over $50,000, needs a majority, or, well, not a majority because you have it, a unanimous vote, which is the same problem theoretically as 50-50, but if you're making it for more extraordinary decisions, hopefully it occurs less often, or maybe it never occurs, and it's an effort to try to manage the operation of a business where you don't end up having to run directly to a lawyer. So I've seen it many times, and I've heard of it many times. It's always the same thing, and the documents always seem to say the same thing. So that's my 2 cents. If for anybody who's listening that owns a small business, small partnership, small close family corporation, this is something
Which would probably be worse.
This is that's
if
something
it's
to seriously
family.
consider.
Yeah.
Sure, you own it with your
Sister, brother.
Yeah, your sister, brother, cousin, and now you can't agree, and now the whole family has to take sides. That's not pleasant.
Yeah. There was just on TV not too long ago a story about maybe in Jersey. I'm not really sure where it was.
Oh, my old haunt.
Yeah, it was a small amusement park along the water.
Oh, there's lots of them.
And I think they're one of the last because they put condos everywhere else. Well, people want their land and they want to buy it to put up more condos. And the person with the controlling
interest,
basically he's got the job of running the whole place. The rest of the family just goes, "Where's my check?" But they're like a board. The whole family was like a board.
Right.
And they're trying to make him sell because the land is worth more than what the amusement park makes per year. So, and it's just tearing that family apart.
I thought that was a movie.
No, it was real.
I could have sworn I
they
saw
could make
a movie.
it's a Lifetime movie, right?
I really believe I saw a movie
Hallmark
like that.
movie?
A guy who wanted to keep the family,
This was an
amusement
adorable little amusement park. I think it was in Jersey.
You sure it wasn't a movie?
No, this was a real
TV
family.
movie?
Real family.
All right. All right. What could I tell you?
Strange Inheritance. I think that was the show.
Well, that sounds like
You've
a
seen
movie.
that? No, it's she goes around. Colby is her name, and she goes around to these people who have inherited strange things.
Right. All right. So let's now then. Anybody? By the way, you got a question?
What's the best outcome for this business that is having a problem?
The best outcome is for one of the two partners to buy each other out.
Okay.
At a fair price. That's the best outcome. The worst outcome is you have to dissolve the business.
Okay.
That's
funny because that's where I started.
There are temporary measures that a judge can impose to try to keep the business operating until you get through a trial, but those are stopgap measures, and they're also expensive because you're involving the court and lawyers and others. So,
do they appoint people to help run the business?
that is one of the options in the statute.
Okay.
Yes, there are several options that a court has in those situations pending a final resolution. But yes, one of them is to appoint, for example, a third director.
Sure, because you would think that if you're angry at your business partner, you could run that business into the ground with your half.
That's true. And, if you're going to have a third person appointed to temporarily resolve disputes until the case winds through the court, that third person is going to have to be paid.
Sure.
Because they're not really part of your business.
Right.
They're just there to...
Because you're not getting along.
Right. So that's another expense. All right, so I was saying, if you have any questions, give us a call at 340-1590. And come on, call me, say hi, say, I can't stand the sound of your voice, whatever you want to say. But give us a call. You have a question on some other topic. I don't care. You want to talk about the government shutdown? I'd love that,
boy.
man. I can talk about that for hours.
Oh, boy.
Doesn't really relate to my practice, but I can talk about that one for hours. So let's talk about another area. Do a lot of landlord-tenant litigation. Now, again, I don't write the leases and things like that, but I get I've represented a few landlords.
I've been a landlord.
But 90%,
sort of.
It's the tenants. And we regularly get calls, my landlord won't fix X, or I'm going to have to withhold rent because.
Now, is this usually a dispute between like someone who owns a home and rents, has like a couple of properties?
No.
Or does it happen with big apartment complexes?
Massive
Really?
complexes, massive
Okay.
property management companies, single family homes. It happens with everybody. And again, we did talk a lot about landlord-tenant on another show, but since it's been a year, who knows how long ago that's been. I might just recycle some of this stuff. But the statute provides what obligations a landlord has to make repairs. It also provides that in certain circumstances, the lease can designate, with the exception of a few statutory requirements, who is going to be obligated to make other types of repairs. And it says L or T, and you go through the lease and you agree. So the first thing you got to do is look at the lease. If you agree that it's your responsibility, you're not going to have much luck in arguing that the landlord won't pay. But if it's a landlord responsibility, one of the first questions we get is, can I withhold rent? The answer is, initially, no. Don't do it. Because the second you do that, your landlord now has a cause of action to evict you for failure to pay rent. And your defense that he wouldn't fix the toilet is not good enough. The fact is you didn't pay rent. Now, if what the landlord has failed to fix causes your residence to be substantially uninhabitable for a period of time, it's infested, it needs to be tented, there's mold, then you have a remedy to withhold rent, but only if you do it in the right way. You can't just withhold rent. In those situations, the statutes require that you send the landlord a certain type of a notice that says, this is the problem. It substantially inhibits my ability to remain in the premises or remain in part of the premises. And unless you fix it within a statutory period of time, I think it's 10 days, I am going to withhold rent, or I'm going to withhold part of the rent if it's not the whole premises. And then you now have a legitimate basis, so that if the landlord then sues you for failure to pay rent, you have a defense that you submitted the proper notice regarding a repair issue. So it's not the failure to pay rent that becomes the issue before the court. It's your issue about the landlord's failure to repair this item. And I've had several cases in Florida, that deal with mold. And if the mold is in one small area of the house, that doesn't mean that you can withhold the entire rent. It's not necessary for you to leave the entire house. But, if it's in the master bedroom, and it's in the kitchen, and it's in the living room, you probably are best not to be there until it's resolved. So now you have an issue where you may be able to withhold all the rent until it's resolved. You may have an issue where if it's not resolved within an appropriate period of time, you may have a right to terminate the lease and get out without the landlord saying you have to pay for the remaining 8 months on your lease.
Or the landlord was going to give you the 30-day notice to leave because they'll just get somebody new in there who won't complain about mold.
Well, if you were month to month, that's true. If you had a lease, it's harder for that landlord to do that. And sometimes you don't want to end your lease. For example, your kids are in school, in that district or near that residence. You don't want to leave. You just want the thing fixed.
It's expensive to move.
Right. Mm-hmm. So here's the mechanism to try to resolve that problem. But if you do it your own way, if you're not familiar with what you're doing and you simply just don't pay the rent, you're going to find yourself on the wrong end of an eviction action. Sure. Okay. Might as well. It's a first for everything. Is it that time?
If you want to, it's just because it's
all right.
Right
well,
at
folks,
that time. If you want to take,
we're going to
do
one of those things we don't normally do. We're going to take a bottom of the hour break for the news because everything is happening in the world right now, right? See you soon.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.
FNN News. I'm Alan Spector. The new governor of Florida is reversing course from his predecessor and asking the legislature to end a ban on smokable medical marijuana. In Winter Park, Ron DeSantis accused lawmakers of failing to follow the will of Florida voters who approved the medical marijuana amendment.
The lawsuit that's challenging the smoking ban, we're going to be filing a stay of decision on that till mid-March, because after all, I served in the Congress. I want to have the elected representatives write the law in a way that the people intended. So we'll give them a couple weeks in session to address the smoking issue. And if they don't do it, we're going to dismiss the case and we're going to move on.
The amendment that legalized medical marijuana was approved by voters in 2016. Then in 2017, the legislature passed a bill that outlawed smoking medical marijuana and banned the sale of the drug in smokable forms. An ICE contractor from California is accused of pursuing a Florida minor for sex. Majid Dedeban is being held without bond after exchanging texts and phone calls with someone he thought was a teenage girl. Instead, he'd been talking to a Palm Beach County Sheriff's deputy since December. A jury in Miami is awarding a hotel dishwasher $21.5 million in a religious retaliation lawsuit. Attorney Mark Brumer represents Marie Jean-Pierre.
The message to employers and to companies, whether big or small, is that you cannot discriminate based on religious beliefs.
Marie Jean-Pierre said the high-end Conrad Hotel knew about her religious obligations when she was hired and did not schedule her to work Sundays for many years. Beginning in 2015, a new boss started assigning her to work Sundays. She traded shifts with other employees for a while but was fired the next year. With news on the Florida News Network, I'm Alan Spector.
Innovation means thinking differently. It means daring to break free from centuries of tradition and valuing opportunity over exclusivity. It means defying the status quo to pioneer what's next. At UCF, innovation is at the core of everything we say and do. That's why U.S. News & World Report ranks UCF among the top 10 most innovative universities in the nation, above Harvard, Johns Hopkins, Duke, and all other Florida schools. Learn more at ucf.edu/big.
An opioid overdose does not need to end in tragedy. At-home rescue treatments like naloxone can help you save a life. Naloxone is available without a prescription and doesn't need to be administered by a health professional. Learn to recognize the signs of an overdose, like unresponsiveness, snoring sounds, and shallow breathing during an emergency. To learn more, dial pound 250 on your cell phone, say the keyword "Save a Life," and you will have the option to receive a one-time auto-dial text message from iHeartMedia. Brought to you by the Florida Department of Children and Families. Standard message and data rates apply.
A Brevard County woman who was supposed to be saving horses is now accused of hurting them. Deputies this week arrested Clarice Austin on charges of animal cruelty. She runs Horse Sisters Equine Assisted Therapy and Rescue in Mims, but Sheriff Wayne Ivey says his deputies found 3 horses there who were extremely emaciated.
This is just a matter of she shouldn't ever be around an animal, and I say that very, very from the deep of my heart.
1 horse was put down, but vets are caring for the other 2. Austin was released on $6,000 bond. The sheriff's office is seeking a ruling that she can't get the horses back. On the Treasure Coast, a large solar farm set to open in St. Lucie County will get Florida Power and Light closer to its goal. The state's largest utility wants to have 30 million solar panels online by 2030. The latest solar farm is set to open in about a month. It will generate enough energy to power 15,000 homes. Alan Spector, FNN.
Such a charge.
Ask a Lawyer continues on WPSL. Phone lines are open 340-1590, 340-1590. Now back to your host, Attorney Stuart M. Address.
All right, folks, before we continue with a little bit more landlord-tenant, we have Roy on line 1. Hello, Roy. How are you? Roy, you there?
Hello, Roy. I already did that.
No, Roy? Roy, if you're listening...
Yeah, see, he's gone.
Yeah, people hang up on me all the time. Roy, if you're listening, give us a call back. We just had to do the news. Be happy to talk to you.
The phone's ringing.
I hear the phone.
So maybe it's Roy.
Maybe we'll get a note in here. All right, so, security deposits. Get a lot of calls about those. There's a statute on security deposits, what the landlord has to do and what you have a right to do. Landlord has to give you a notice in the beginning as to what is being done with your security deposit, where it's being deposited.
You mean at the time when you sign your lease?
Right.
Okay.
Usually it's being commingled with other security deposits, which is fine. Usually it's not in an interest-bearing account, and that's fine too. Mm-hmm. And then at the end, I'd have to look at the statute. Within a certain period of time, I think it's 30 days. The landlord has to send you a notice, either has to send you back your security deposit, or a notice that it intends to withhold X amount or all of the security deposit for the following reasons. You then, under the statute, have a right to send back a notice that says, well, I disagree. And if you disagree, the landlord cannot take any of that security deposit for himself. It gets resolved in court. And it's not an expensive proposition. It's resolved in landlord-tenant court. We got Roy on line 1?
We have Roy on line 1.
Hi, Roy. How can I help you?
Yes, I'm a Korean veteran, and a group came to me and said I could apply for a pension through the Korean student government, or the VA. Inadvertently, now I think I'm going to be charged like $2,000 a month for this pension that I didn't receive, but the money was deposited by the VA into my bank account. And I do believe that they're going to come after me for the $2,000 a month.
Okay, the money was deposited in your bank account, but you didn't receive it?
Yes, I did receive it from the VA.
Okay.
And this group that signed me up had nothing to do with the VA.
Okay, so somebody signed you up for something in terms of a pension, and it wasn't a government agency, it was a private agency that told you they can get you something.
Which they did.
Oh, they did get it for you.
Excuse me, sir?
You're saying they did get for you what they said they could get for you?
Yes, but now they're going to, for 3 months, while they were attempting to get this, they were charging me unknowingly $2,000 a month. And I'm sure they're going to come after me.
Did you have a signed agreement with them?
I'm legally blind, and I probably did.
All right. That signed agreement is obviously, I suspect, going to say what their fee is and how they charge it. If they're not doing what is in the contract, then you would obviously have a claim against them. However, if they are doing what's in the contract, then the only possible claim would be if they took advantage of you. You say you're legally blind. If they took advantage of you, then obviously you need to talk to a lawyer, because not only is that potentially a civil case, but there are criminal statutes about taking advantage of either, the elderly or people with disabilities.
Would the VA be able to help him too?
I probably not.
The VA said it's a fraudulent outfit, and I'm 87 years of age, and I guess by the time they try to get money out of me, I'll be dead.
Well, okay, Roy, my suggestion is that I'm not sure where you live, but that you contact a lawyer.
Okay.
And you get yourself a consultation, and you bring in whatever documents you have from that outfit and from the VA, and have somebody in your area that is competent try to unwind and figure out what's going on, because only then can you really get good advice as to what you can do about it. And obviously, if you're being taken advantage of, it should stop.
Okay, well, thank you so much.
And by the Roy, really, I mean with all my heart, thank you for your service.
Thank you again. Bye-bye.
Bye-bye. Well, unfortunately, that also happens all too often.
Mm-hmm.
That's why there's criminal statutes on it. And, there's lots of significant civil claims. But even without those extenuating circumstances, a lot of times people come in and, they've signed a contract, and either what is happening is not what's in the contract, or this happens with autos all the time. My goodness.
But this seems kind of, suspicious to me that it's a third
Yeah,
party
yeah.
helping someone get their VA benefits. VA benefits come from the government. They have a specific way that they do things.
Right, but just like an attorney might help you, I don't know that it's necessary against the law for a third party to help facilitate applications, things like that. But what you often see is those third parties charge exorbitant fees.
Sure.
And unless you realize what you're agreeing to, then when they finally are able to get you what you could have obtained yourself, you owe them a lot of money, and that's a big problem. So, when we were going back now to, trying to finish up on a little bit of the landlord-tenant stuff, when you withhold rent, and when you hopefully do it in the proper way, you should segregate that rent. You're not going to hear the questions on Facebook Live, sorry. That's the way it is. You'll have to listen on YouTube when WPSL posts it, if you want to hear the question. One day we'll get to a different technology where you folks can hear the questions.
We'll figure it out.
Hopefully you need to segregate that money that you're not paying. Preferably put it in a separate bank account so that you can always show that it was not your intention to keep the money not to pay the rent. It was your intention to withhold it. You sent the proper notice, etc. Then once the landlord files an action to evict you, you must deposit that money into the registry of the court. And you must keep depositing the full amount of the rent into the registry of the court until the matter is over. Because if you fail to deposit the money into the registry of the court, you lose. Simple as that. Doesn't matter how right you are, what you can prove. If you have not paid the money in dispute into the registry, it's as if you failed to pay rent and you're evicted. So those are some basic things about things we get calls a lot of times. They're easy solves if you do it the right way. So it's sort of a shorthand of some quick and dirty stuff on landlord-tenant that comes up a lot that, hopefully might help people down the road.
The security deposit situation, though, now with the technology that we have, it would be really super easy to walk through that empty apartment or home or whatever you're renting, document that, and also document, usually there's a visit. A representative from that property will walk through and let you know whether or not you're getting your deposit back.
Oh, no, that doesn't happen. No, gosh, no. I haven't seen that happen.
Really? I would have a problem.
I
haven't rented in a long time, so
a lot of times there's the pre-checklist where you're told to walk around the property and unit.
Yeah, but
and
they don't care
everything
about
that's wrong.
that. Yeah,
but that helps you to show that you didn't cause this crack.
Mm-hmm.
But the reality is you're not going to find everything because you're not going to know to look at everything. Oh, 1 second. Yes. Canceled. I just sighed a big sigh of relief, folks. I just got a message. Very important message. Cheryl, I'm sure, is cheering at my office. Give her a call. I don't want her to cheer too much. She's supposed to be really busy right now preparing for a trial on Tuesday. And now she's probably saying, whoop-de-doo, I don't have to do anything today. So give her a call at 781-8003 and make her work hard by
give her something
asking
to do.
her legal questions and telling her you have potential cases and making her talk to you for 15, 20 minutes at a time, so she can talk to me and, just don't let her off today, please. It's Friday, don't let her off. Cheryl's going to kill me. No, I just got a note. We have a trial that was set for Tuesday. In Vieira. I've never been there. And we had subpoenaed a witness, and that witness contacted us a couple days ago and said, I can't come to the trial. I won't be in town. And my instructions to Cheryl were to let that witness know, you're in town now, you've been subpoenaed, you'll be in court.
Yeah.
Or we'll
find. I didn't think it worked that way.
Or we'll seek to have you held in contempt.
No, I can't be there. I didn't think that would fly.
Well, we got a response then that sort of, it was not going to be so easy to hold this person in contempt because she explained that she was flying to Alaska because her daughter was having a C-section on the Wednesday after the Tuesday trial. And I have a feeling the judge would have excused her from the subpoena, which meant we were without a witness that was needed.
Mm-hmm.
And so we set about the laborious process of trying to continue the hearing, which is fancy legalese for cancel it for now and reschedule it. But the reality is you can't do that on your own, or even with the other side's consent, which we had, when you have a hearing of a certain period of time or more. The judge has to agree. Now, most judges are accommodating. There are judges, however, that say, I booked a day on my calendar. You're not going to tell me at the last moment that you need more time, and I have nothing to do with anybody else because I can't book anything. So your trial is continuing. And then all you really have about that witness is the right to an appeal if things go south.
Mm-hmm.
So I really didn't know from yesterday to this morning whether or not this trial was happening or not happening, and apparently it's not happening, which makes us have the time for the witness to return from Alaska and to be properly compelled to be in court when we are rescheduled. All right, so enough about me. I'm just very happy right now, I tell you. It's a relief.
That's a great way to go to the weekend.
Now, I'm going to say, here's a great example. Look, this is an instructive thing. I'm very happy right now. I'm happy because we don't have to go to a trial without a key witness. Good reason for me to be happy. That witness is going to make it more likely that I could prevail for my client. The client was okay with me seeking to continue the hearing. I explained to the client the options, and the client made a decision. Okay. I'm thrilled. Even though the client agreed, I'm sure the client's not all that thrilled, because now something is being postponed that the client wanted to get relief on.
And they were probably ready.
Yeah, and not only just ready, but emotionally ready.
Mm-hmm.
This can be emotionally trying on people. I've had this particular client in my office 3 times in the last week preparing. It takes an emotional toll. And to then be told it's not going to happen, and in 2 months we'll prepare again. Because you got to prepare them again. You can't just rely on you prepared them 2 months ago.
Sure.
You know, you got to go through the examination again and make sure their answers are consistent, and the documents are the right documents. So they got to go through it again. And it's another emotional toll. And more fees.
Mm-hmm.
So, again, there are consequences to everything.
And it could be even time away from their job or time away from
That's right.
things that they had to take
Well, this is
care of.
one of those 50-50s that I was talking about.
Mm.
Okay? And this really happens, and you really end up going to court and fighting over this stuff, and it costs a lot of money. And then when a key day comes where you might get the temporary relief you're seeking and maybe avoid an entire trial by getting your temporary relief and getting the other side maybe to let you buy them out at a reasonable price, now it's postponed.
I'm a person who believes that things happen for a reason.
I hope so. Hope it's a good reason.
Mm-hmm.
But everything has a consequence, and it's another good example of why ultimately the clients have to make the decision. All I can do is lay out the alternatives. In this case, there were a couple. There was seeking to continue it, going ahead without that witness and seeing how we can manage to deal without that particular witness. And then there was a evidentiary issue, which I can't say just in case somebody is listening, where I had a certain way that I might be able to admit certain things into evidence without that person. But it was a gamble because there's a little bit of law on it, not very much, and not very much in Florida. And so this judge could have heard the cases I had for admitting these documents and said, yes, that makes perfect sense to me, and we didn't need the witness. Or the judge could have said, no, I'm sorry, that's not settled in Florida, I'm not going there, and we're out of luck. So ultimately, the client, I explained all that to the client. If you want to take that chance, I mean, I have good law, I think it's a good argument, but I don't know what this judge is going to do. We can take that chance and get us ready for Tuesday, or we could, seek to continue it. And the client made the decision. I'm sure, with some regret, but, the attorney is not the one.
I would have wanted to proceed as planned.
And risk sabotaging your own?
No. What you had planned with the witness.
Oh, right. Well, that means a continuance.
Yeah. But
right.
Everything was up to the judge.
Well, yes, ultimately.
Either way.
The other counsel said yes to continuing because what did they care? They were being asked to being compelled to do something. So if they don't have to do it now, if in case they lost, no skin off their nose. But yes, the judge here had to say it's okay. Otherwise,
is there any risk in giving them more time to prepare?
There is. There's always risk giving the other side more time to prepare. There's always risk that the other side, figures out what you have planned. In a real trial, a full trial.
Sounds like a Perry Mason episode.
Well, there is a lot of case law that says trials are not meant to be trial by sabotage, trial by surprise. That's what discovery is for. So before a full, real trial on the merits, in most states and in Florida, you've exchanged your witness lists, your exhibit lists. They know what documents you're going to be introducing. They know who your witness is going to be. They know who your expert is if you have one. They've taken their depositions. Both sides have a pretty equal opportunity to prepare. When you have a hearing, even if it's an evidentiary hearing like this one was going to be, there is no such requirement to exchange all that stuff. So we actually had a leg up in that they could guess by what we're seeking what we were likely going to do, but they couldn't really know. And similarly, we couldn't really know how are they going to defend against this. It means both lawyers have to do a lot of ability to think on their feet. But yes, more time means more opportunity for both sides to figure out what's going on with the other side.
You've seen the movie Liar, Liar?
Yes.
I was thinking on your feet.
Yes. Run into the restroom and try to tell the truth, and yes, it doesn't work. Hey, I know lawyers who can't tell the truth. Trust me, I know them. I know them very well. I know them when they're in a courtroom and not a word that comes out of their mouth is the truth. I won't name names because then they'll sue me for defamation. I'll have to defend with the defense of truth, and it'll still cost a lot of money. So, even though I would win, why buy a defamation suit? Which is what I tell people a lot of times. I mean, do you have the right to do this? Yes, you do. There are going to be consequences. You're probably going to win, but do you want to pay me $20,000 to win, or do you just not want to do it in the first place? So the sign outside my door. It says attorneys and counselors at law. That goes back to the old days, common law, and it probably had its own meaning, and I'm not sure what its real meaning was, but it has a meaning to me. And sometimes situations arise in my office where I explain that to a client or a potential client. As an attorney, it's my obligation to give you legal advice.
Yeah, that's the law part.
As
That's
a
the way I look at it.
counselor, my obligation is to say to you, yeah, you have these legal rights, but do you really want to go that route? Or is maybe this a better route for you? And that is more the practical realities. I used to have to tell my father sometimes, yeah, you have a legal right. You don't really have an effective legal remedy. And that's just the way it is.
Right.
So we could...
Without the remedy, why have a case?
Well, we talked about HIPAA, right? HIPAA has no private right to sue. So without a private right to sue, what is the real purpose of HIPAA?
To not let your family call in and find out how you're doing?
Maybe. But it's not to prevent somebody from looking into your file and telling somebody else about it and maybe costing you your job.
Right. Or selling a list that, so that they can solicit you for things.
If you had the private right to sue, then there's more teeth to it. So this is only a few weeks ago we talked about this. So a creative attorneys, not me, creative attorneys in other states have begun to use other theories to try to go around the fact that HIPAA doesn't allow you to sue under it. And they've argued invasion of privacy, other common law torts, with some success in other states. And it's only a matter of time before it happens here, whether it's me trying it or some other attorney trying it, and maybe winning, and then the other side appeals, and then an appellate court says, yeah, this is going to be the law in Florida, or it's not. Or,
If nothing, you set precedents.
Well, hopefully, if nothing else, because hopefully you want to get paid.
Yeah.
Yeah, that's another thing. Yeah, it's hard to learn this when, when I first started working, I was with a 200 attorney firm in New Jersey. And then I moved to South Jersey, I was with like a 150 attorney firm. And you don't understand any of these things about it's a business too.
Mm-hmm.
To you, it's just this noble occupation and you have these lofty goals. But then when you open up your own practice and you're paying the salaries and you're paying for the stamps and the ink, you realize that as much as you might want to help everybody, it is a business. And you have to have the proper mixture of contingency fee cases where you're not getting paid unless it's a settlement or you win, and hourly cases, which are paying the bills. Because if you can't pay them, you go out of business.
Mm-hmm.
And so sometimes...
And these things don't happen quickly either.
No,
I mean,
they
these
don't.
cases don't settle quick. So you're waiting.
When I take on a discrimination contingency fee case or a civil rights case, it could theoretically be 2 years before I get into a trial. And during that 2 years, I have a couple cases where this has happened. I might put in over 1,000 hours of time. Depositions, discovery, all sorts of things. That time is not being paid for by anybody. And if I'm paying costs out of my pocket, depositions,
Sure.
transcripts.
Well, even just to keep the lights on.
You know, but if I'm paying hard costs for a case, I can spend $20,000 and still I'm not getting paid. So when you are choosing which cases to accept that are contingency fee cases, there are a lot of hard choices that have to be made as to, is this really a case that I'm willing to take that chance? And on contingency fee cases, most attorneys look at it this way. If I were to try this case 10 times before a jury, how many times do I think I'm likely to win? Because you have different juries. You can never count them.
Right. Mm-hmm.
And usually it takes an attorney to feel confident that based upon the facts I know right now, which can change in a month when you find out things that your client didn't tell you, but based upon the facts I know right now, I think I'd win this case 8, 9 times out of 10. Okay, you take it. What about the case you think is going to win 7 times out of 10? That's a real hard call. Sometimes you really like the case, and the person has really been harmed, and you want to help them. And what about the case that you think is going to 5 or 6 times out of 10? It's a toss-up.
Mm-hmm.
It's hard to take those. Very hard to take those. And sometimes what I have to say to people is, you need to go to a larger law firm that has the ability to absorb more risk. Because there's only so much risk I can absorb.
Right.
And if I have 4 or 5 other cases that have that level of risk, I can't do it.
Mm-hmm.
So you have to evaluate this stuff very carefully. But when you are able, on the non-hourly cases, when you are able to get a quick settlement, and, it's nice that you get your fee. It's very nice that you get your fee. And when the fee is a good fee, it's really nice that you get your fee. But the benefit that you've done for your client, both monetarily and emotionally, is often immeasurable. If your client has claimed sexual harassment or racial discrimination or has been pulled over by the police and targeted, and now they've had to settle and pay money, there is some sense of, I did not stand by idly and do nothing. So, you get tied up in these cases, and it's very hard in determining what cases to accept and what cases not to accept. And I'm told by fingers being pointed at me, hopefully not the middle finger, that I'm basically running out of time. I have less than a minute. So let me say this. Thanks for listening. Give us calls. Next week's the first year of Ask a Lawyer. We've been renewed by the law firm of Dewey, Cheatham, and Howe. And on February 1st, we will have a guest attorney to talk about workers' compensation, Social Security, disability. Until then, have a wonderful weekend. I'm Stuart Address, and this has been Ask a Lawyer. Bye-bye.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.
This is CBS News on